So I'm Judge Larry VanMeter. I grew up in Winchester. I'm a judge currently on the Kentucky Court of Appeals. I've been on Court of Appeals for 13 years. Before that, I was a judge of the Fayette Circuit Court. Before that, I was a judge of the Fayette District Court. And before that, I was an equity partner at a large law firm in Kentucky, Stahl, Keenan and Park, where I practiced transactional law, which basically is a way to say that I worked in equine law, business organizations and planning, taxation, real estate, trust, probate, estate administration, estate planning, basically transactional practice where my job was to help people realize their goals, whether they were business, professional, personal.
So you've been in law a long time.
I have for 33 years.
So I'm guessing that's kind of why you were ready to take this next step and run for this role.
Right, exactly. And so what I think is why am I running for the Kentucky Supreme Court? The reason I'm running is that I think my background, both in law practice and as a judge for over 22 years at 3 levels, District Court, Circuit Court, Court of Appeals, gives me a unique background to qualify me to do the job, not only to do it, but to do it well.
Now, what do you view as the role of the Supreme Court overall?
What I believe is the Supreme Court really has 2 roles. It is, in some ways, an adjudicative role. It runs the court system of the Commonwealth. It promulgates rules, regulations for the practice of law, civil courts, criminal courts, family courts, juvenile courts. It also oversees the practice of law, attorneys, judges. But it also has, very importantly, and I think the most important function is the adjudicative function that it carries out. It's the final determinant of what the law of Kentucky is. I mean, subject, of course, to an appeal to the U.S. Supreme Court, but basically it is the final determinant of what the law is in Kentucky, and it needs to be based on the Constitution, the statutes, and the prior case law of the Commonwealth.
Now, in your opinion, how much should a Supreme Court judge weigh the priorities of the business community and healthcare providers when making decisions? How much should you think about that when making a decision?
Okay, and I've thought about this as well, and I know probably what the answer might want to be, but truly, we're not advocates. We're sort of like the umpires in a sports contest. We're there to call the balls to strikes, to enforce the rules. In any given case, the outcome might be disappointing to a given business, but I think long-term what businesses want is they want certainty and predictability in the ruling. They want a uniform body of law. Well, the one thing I've thought about, and not to be too flippant, but for example, no one ever asks us, are you anti-crime? Everybody is anti-crime. There's no one who is pro-crime. But as a practical matter, everyone knows that judges sometimes have to issue decisions, opinions that have the effect of letting someone, reversing a criminal conviction for a new trial, or in fact, letting someone that we all know is guilty go free. I mean, that's the way it works. I think, personally, I agree. I want Kentucky to have a pro-business climate, to low taxation, one that is friendly to business formation, relocation, low taxes, great transportation, takes advantage of our location in the middle of America. But truly, those issues really are legislative issues and executive branch issues, and that's not what I'm running for. I'm running to be a justice on the Kentucky Supreme Court, and again, that's our role, is to adjudicate what the law is and to provide long-term stability and predictability for the Commonwealth.
Now, currently, do you see any big legal issues that are affecting the business community or health providers?
Sure, absolutely. One, which you might not think about, is the pension crisis. And the pension crisis is very real. Have been on the Judicial Form Retirement, so I get to see it up close and personal. I go to the Public Pension Oversight Board. Long term, this is an issue that affects all businesses because it sucks the resources out of what is otherwise able to be provided to transportation, education, the court system, that affect businesses in a very real way. Another one is the heroin crisis. And as a court system, we need to find out what our role is working with the executive branch in coming to grips with this. Clearly, it's going to affect the business's ability to hire and retain qualified personnel. I think more directly, legal issues are a recent change that, well, not recent, over the last 30 years we've gone from a contributory negligence system to comparative negligence. And in some ways that change is still being worked through. One good example is recent changes in the law having to do with premises liability. That affects businesses. Certainly other liability issues and administrative issues affect, which we could talk for a long time about that. But I think really long term what businesses want is they want predictability and certainty in what the law is going to be, and that's what I try to provide.
Now, what type of policies do you think should be adopted by the Kentucky court system that will address some inefficiencies, especially with civil cases, civil matters?
Okay, I've thought about that, and really what the question is it addresses the fact that litigation is expensive, it's long, and it's stressful. It's stressful for litigants, and I know that. Two things that need to be worked through with the General Assembly are uneven allocation of judicial resources and family courts. And part of that is, as population in Kentucky has moved over time, people have left Eastern Kentucky, South Central Kentucky, West Kentucky, and everyone is moving to Central Kentucky, Northern Kentucky, and Louisville, right? So what's happened is our judicial resources are not, they haven't changed with that. And this is a large issue that needs to be addressed with a number of constituencies, not just judges, but Commonwealth attorneys, the legislature, to try to match up our judicial resources with what the caseload needs are. With respect to family courts, certainly not every jurisdiction has a family court. If every jurisdiction did have a family court, that would then leave civil criminal judges to deal just with those issues as opposed to family court issues. But those issues have to be done through the legislature, and certainly I think that's something that the court will be working with the legislature over the next two bienniums to get done. As a court system, though, one thing we could do is amend civil rules. One thing is to adopt the proportionality rules that have been adopted by the federal courts to make discovery attuned to the needs of the litigation and the resources of the parties. That could be done. We should dust off the expedited docket litigation where those rules are actually in place, but they've only been adopted in a number of circuits. Now, some judges and some attorneys think not every case needs to be on an expedited basis, but certainly there's a place for those rules, and they need to be further dusted off and considered and maybe put into place in more places. We have e-filing. We need to make that more streamlined, more efficient. We need to have it apply to the appellate courts. We need to make it truly seamless like is in the federal system. One thing we could also do is we could provide for telephonic or Skype type motion practice or pretrial hearings. A lot of attorneys practice over a wide geographic area, and so if an attorney's in Louisville, Lexington, or Northern Kentucky, or any other place in Kentucky, but they have a practice that takes them to more remote parts of the state from where they are, if they didn't have the travel, you can't really work when you travel, but you have to bill for it. So clearly that is another expense, and if you could provide a rule to make those more functioning in terms of telephone or Skype, they just would save that cost.
Now, considering the many opinions that you've written as an appellate court judge, is there one or two that you think really kind of represents your judicial philosophy? Okay,
well, there's a list. There's a long list, and I have the list right here, but I won't bring those out. The theme of those cases is that, notwithstanding what my own personal preference might be, or what I think of the outcome of the case, I'm obligated to follow the rule of law, to apply the statutes, to apply case precedent. And sometimes the results are harsh. And one really good example, the question that was given to us before the interview was your appellate opinions. Mm-hmm. Well, actually, I've been a judge at the district court and the circuit court levels, and I am the judge who issued the first opinion with respect to the smoking ban ordinance in Lexington. My personal opinion was that the smoking ban enacted was too strict. If it were up to me, I would have allowed the market, let individual businesses decide, are we going to permit smoking or not? And then let customers decide, am I going to patronize the business or not? But when I reviewed the case law was clear that if an ordinance had to do with public health, a local governing body could enact it. So notwithstanding my own personal preference, I upheld the ordinance, and it was fast-tracked to the Kentucky Supreme Court, and that ordinance and my decision was upheld by a 6-1 vote.
Wow, okay. Now, at the federal U.S. Supreme Court level, is there any justices past or present that you look up to the most?
Okay, so I've thought about this one as well, and I'm gonna take you way back. Okay. John Marshall Harlan was born in Kentucky in 1833. He died in 1911. He was the son of a slave-holding family. He fought for the Union, though. He was a Union, I'm not officer, I think maybe a major or a colonel. But he was appointed to the U.S. Supreme Court in 1873. And by the current standards of today, we would not be too pleased with his personal views with regard to race. We wouldn't. But legally, there are 4 cases in the history of the United States Supreme Court that everyone agrees are just the worst cases ever decided. One is the Dred Scott case before the Civil War, Plessy versus Ferguson in the 1890s, one called New York versus Lochner versus New York, which was in 1905, and one called Korematsu versus United States, which occurred in World War II. John Marshall Harlan wrote dissents in 2 of those cases, Plessy versus Ferguson and the Lochner case. He also wrote a dissent in a case called the Civil Rights cases. In Plessy versus Ferguson and in the civil rights cases, the majority of the U.S. Supreme Court basically gutted the civil rights legislation that had been enacted after the Civil War to give effect to the 13th, 14th, and 15th Amendments. John Marshall Harlan, notwithstanding what may have been his personal views, wrote these great dissents, basically saying that every man, every woman is equal before the law, and these cases are not in keeping, the decisions are not in keeping with the colorblind nature of our Constitution. So even though he, had grown up as he'd grown up, he is regarded as one of the great jurists. He's called the Great Dissenter. So I think that, plus the fact that he was from Kentucky, he's one that I admire for those legal opinions.
Now, you've touched on this a little bit, but overall, how would you approach your role as a Supreme Court justice if you are elected?
My role would be, again, keeping with the fact that the number one role of the Kentucky Supreme Court is an adjudicative body. Based on my experience as a transactional lawyer, again, business organization and planning, equine law, taxation, real estate, there's no justice or candidate for the Kentucky Supreme Court who has this background at the level and extent that I have. In addition, 22 years as a trial judge and as appellate court judge, only one justice on the Kentucky Supreme Court has been a district judge. In fact, I'll become, if successful and elected, I'll become just the 3rd person ever to have served at all 4 levels, district, circuit, including family, because I did that, Court of Appeals, and Supreme Court. So this background, as I've said, is unique. It uniquely qualifies me not only to do the job, but to do it well, to issue opinions, to bring common sense, based on the notions of predictability and certainty, recognizing, of course, that change does occur, but when change does occur, it needs to be well considered. And it doesn't need to be done just because, we're the Supreme Court, we can do whatever we want. Once decisions are issued, right or wrong, people start to plan based on the case law, the statutes that are in effect. And the Supreme Court's job is not to, well, we can do whatever we want. You have to consider the fact that businesses, people plan based on what's out there. So that's what I bring. We're not running for some narrow, we're not running to be a hearing officer or an administrative law judge, or, we need someone who has had trial experience as a judge, who knows the pressure of making those quick decisions. Not every decision, no trial is perfect. And so there's some errors that are just harmless error. I mean, they might be a mistake, but you look at the entire case, and is the result the correct result? I mean, those are both in the civil rules and the criminal rules. So I think that's important. Someone who has actually been on the front lines as a judge, district judge, circuit judge, Court of Appeals judge, and it has made those decisions for a long time.